All right, we're going to review the full filing here for Canoo v. Harbinger Motors. It is 58 pages long. It can get very repetitive. We're going to try and go through it as quickly and concisely as possible. But before we get started, I should point out, of course, that in the United States, you are innocent until proven guilty. Just because Canoo has made these allegations against the defendants does not mean that they are true. The guilt is not predetermined or pre-concluded, and so they'll all have their day in court to try and defend themselves against the accusations. So we're just going to go through and see what those accusations are and how Canoo words them. So there are 17 complaints here. Number one, misappropriation of trade secrets in violation of the Defend Trade Secrets Act. Number two, misappropriation of trade secrets in violation of the California Uniform Trade Secrets Act. Number three, breach of the Confidentiality Information and Inventions Assignment Agreement. Number four, breach of the Employee Separation Information Letter. Number five, intentional interference with contractual relations. Number six, negligent interference with contractual relations. Number seven, tortious interference with prospective economic advantage. Number eight, negligent interference with prospective economic relations. Number nine, breach of fiduciary duty. Number 10, aiding and abetting breach of duty and loyalty. Number 11, breach of duty of loyalty. Number 12, aiding and abetting breach of duty. Number 13, fraud in the inducement of the Confidentiality Information and Inventions Assignment Agreement. Number 14, fraud in the inducement as to the Separation Information Letter. Number 15, unfair competition in violation of California Business and Professions Code. Number 16, unjust enrichment. Number 17, specific performance. And we see here at the bottom that they have a demand for a jury trial. There we go. And as far as who Canoo is suing, it's quite a long list. It's a mix of ex-employees, co-founders of Harbinger, and financial backers of Harbinger. If you do want to know a little bit more how that breaks down, you can head over to canoers.com, and there is a story about it. Canoo files suit against fellow EV startup Harbinger Motors and ex-employees. So go ahead and head over there. There'll be a link in the description if you want to check that out. Okay, start off with here we have an introduction and a number of paragraphs here that Canoo dives in and kind of explains what the filing is about. So paragraph number 1. This is a case of corporate espionage by a group of serial grifters who infiltrated Canoo to steal its intellectual property, including its confidential information and trade secrets, and human capital to create defendant Harbinger Motors, now a direct competitor of Canoo in the fiercely competitive marketplace for electric vehicles. Footnote number 1. Canoo's allegations of intellectual property theft involve national security concerns. Canoo's intellectual property forms the basis for contracts that Canoo secured with both NASA to provide crewed transportation vehicles for Artemis lunar exploration launches, and with the United States Army to provide light tactical vehicles. The capabilities and vulnerabilities of Canoo's intellectual property, now in the hands of Harbinger, could prove beneficial to adversaries of the United States government. Harbinger has at least one foreign investor that may have access to Canoo's stolen intellectual property. Okay, paragraph number 2. Defendants Philip, I'm just going to call him Wicker because it could be Wickier, but let's just go with Wicker. Sorry, I don't really know. William Eberts, John Harris, and Alexei Charbonneau. That's another assumption on how that is pronounced. Former colleagues at Faraday and Future always intended to own and control their own EV company, and they were determined to do so without letting anything get in their way. So when Wicker and Charbonneau left Faraday to join Canoo, where Eberts later joined, it was merely a stopping point, not a final destination. And footnote number 2. It is telling that Harris never joined Canoo, and Eberts left Canoo 11 months after joining. Both knew that they would later join Wicker and Charbonneau at Harbinger. Paragraph number 3. As such, when Canoo required Wicker, Charbonneau, and Eberts, like all employees, to execute broad confidentiality and invention assignment agreements, they never had any intention of honoring those commitments, knowing full well Harbinger was on their horizon. In all, Wicker, Charbonneau, and Eberts misappropriated vast amounts of Canoo's financial resources, business plans, human capital, trade secrets, and other intellectual property, and conspired with Harris, who was employed elsewhere, to form Harbinger using Canoo's stolen intellectual property. Footnote number 3 reads, this is not the first time Eberts, Wicker, and Charbonneau have been linked to allegations of trade secret misappropriation. 4 years ago, they were key players in a virtually identical trade secret misappropriation scheme involving their former employer's EV technology. All right, paragraphs 4 and 5. This is where it starts to get interesting with new information that we haven't heard before. Canoo's key trade secrets are embedded in its skateboard technology, which can be used to convert gas-powered vehicles to electric at minimal cost. Paragraph number 5. After developing its skateboard technology, Canoo invested heavily in building business plans to commercialize its EV technology. Canoo retained a world-renowned consulting firm to assist Canoo in formulating, vetting, and proving a business plan centered solely around its skateboard technology. Canoo's skateboard business plan included exploring joint venture opportunities with third-party original equipment manufacturers, or OEM, including Morgan Olson, or MO, who could integrate Canoo's driving platform into their pre-existing fleet of vehicles. Over the course of a year and a half, Canoo negotiated a potential partnership with MO. If you're wondering who Morgan Olson is, the only thing you really need to know is that they are North America's #1 producer of walk-in step vans. So they're the largest upfitter that many well-known, prestigious Fortune 500 companies use. Bimbo, UPS, FedEx, a lot of brands use them to upfit for their delivery vans. All right, back to the filing. Paragraph number 6. Wicker, Eberts, Harris, and Charbonneau conspired, stole, misappropriated Canoo's skateboard technology and skateboard business plan for Harbinger's use and benefit, enabling Harbinger to develop a business model targeting OEM partnerships, like Canoo, using a skateboard driving platform, like Canoo, developed by former employees from Canoo. Harbinger's illicit scheme has proven to be a financial success, as Harbinger recently announced its own highly profitable joint venture with MO. Footnotes number 5 and 6. Indeed, many of Canoo's former employees who now work for Harbinger are pursuing intellectual property protection for trade secrets, patentable inventions, original works of authorship, trade dress, and designs that Canoo believes belong to, or are based upon, Canoo's trade secrets and confidential and proprietary information. These former Canoo employees are contractually precluded from disclosing, using, or discussing Canoo's confidential information and trade secrets. Canoo is therefore the rightful owner of these misappropriated intellectual property assets. Footnote number 6. As Wicker was instrumental in the negotiations and exploration of Canoo's relationship with MO, Wicker, Charbonneau, and Harbinger sabotaged Canoo's relationship with MO while using Canoo's confidential information and skateboard business plan to assist Harbinger in forming this joint venture with MO. Paragraph number 7. This is not a case where a couple of employees left the company to work for a competitor. This is far worse. Using Canoo's confidential information and trade secrets related to Canoo's employees, including their skills and training, Harbinger, through Eberts, Wicker, Charbonneau, and Harris, strategically recruited at least 33 of Canoo's employees to join Harbinger, making up approximately 66% of Harbinger's total workforce. Footnote number 7. Defendant Michael Fickow Michael Fickow merits particular scrutiny. Fickow served as Deputy General Counsel for Canoo for 3 years and had intimate knowledge of Canoo's intellectual property portfolio and global business development plans. Rising within the company to vice president, Canoo trusted FECAL to provide counsel free of fraud, theft, and divided loyalty. FECAL grossly abused that trust, stealing untold amounts of Canoo's privileged documents and communications, intellectual property, and even misrepresenting on several occasions that he would not join a competitor. FECAL's actions are particularly egregious when measured against the conduct of a licensed attorney, now Harbinger's general counsel, secretary, and head of corporate development. Okay, paragraph number 8. In sum, Canoo's skateboard business plan is the foundation of Harbinger's operations, and Canoo's intellectual property is the foundation of Harbinger's driving platform. By misappropriating Canoo's intellectual property and building a team consisting of Canoo's former employees, like defendants Charbonneau, we're just going to call him Mr. F, Michael Mr. F, and Jigar Patel, Harbinger was able to raise millions of dollars, attracting investors who were willing to turn a blind eye to such conduct to enjoy a shortcut to success. The Harbinger investors were given an opportunity to invest in a ready-made EV company and bypass the significant time, design failures, and money necessary to independently develop a sophisticated EV platform. All right, the next bit goes through the different parties, and like I said earlier, you can just go to the Canooers article if you want to kind of break down how that works, what each party does. Although we'll point this out. Bharat Forge invested in Harbinger and has access to the intellectual property stolen from Canoo. Such access by a foreign entity involves national security concerns because Canoo's trade secrets, which serve as the basis for Canoo's contracts with NASA, United States Army, could either be used to either directly harm the United States government or to provided and or be sold to adversaries and foreign governments, including near-peer competitors like China and Russia. The next bit here goes to jurisdiction venue. It's in California, yada, yada, yada. All right, we have subheading General Allegations, Part A. Canoo is formed as an EV industry disruptor. And they kind of just reiterate a little bit about themselves. The whole point here is that their business plan is proprietary and highly differentiated platform. The skateboard really is the core of the Canoo, product, what they bring to market. Skip down a couple more paragraphs to 37. Canoo's skateboard technology is uniquely well suited for step van delivery vehicles, where separate chassis remain in use for nearly all iterations of delivery vans. As such, Canoo invested heavily in developing business plans centered around the skateboard technology, which included exploring joint venture opportunities with third-party OEMs who could implement Canoo's driving platform into their pre-existing fleet of vehicles. Because Canoo's skateboard technology could help OEMs expedite the conversion of its gas-powered fleets to electric at minimal cost to the manufacturers, these joint venture opportunities became pivotal to Canoo's long-term success in the crowded EV market. Paragraph 38. To that end, on or about August 24th, 2020, Canoo entered a mutual non-disclosure agreement, or MNDA, with MO. The MO relationship represented an important opportunity for Canoo to expand its growing business. If Canoo could form a successful partnership with MO, Canoo could expand its skateboard business plan to other OEMs. Paragraph 39. In connection with such discussions, MO revealed to Canoo what it was looking for, including vehicle specifications, intentions, timelines, pricing information, and the structure of the desired relationship. Canoo and MO and its parent corporation, Poindexter JB & Company, worked together to explore the potential partnership for over a year and a half. In September through December 2020, and in conjunction with Canoo's exploration of the skateboard business plan, Canoo spent tens of millions of dollars to engage a world-leading business consulting firm to analyze EV markets, business opportunities, market penetration strategies, customer interests, competitors, market demand, and a general assessment of Canoo's relative competitiveness in the EV space and its skateboard business plan particularly. Paragraph 41. According to this comprehensive analysis, selling Canoo's skateboards to OEMs like MO was potentially highly profitable. Canoo therefore moved forward and pursued the MO partnership. Okay, next up we have Part B. Canoo's success depends on protecting its trade secrets, and they kind of run through what reasonable steps they've taken to protect their IP from bad actors, if you will. And paragraph 45, Canoo requires its employees to execute a confidential information and inventions assignment agreement as a condition of employment, so that all the accused parties here would have signed this agreement when they became employees of Canoo. The confidentiality agreement prohibits, among other things, the unauthorized disclosure and use of Canoo's confidential information, bars employees from discussing, disclosing, using Canoo's trade secrets and confidential and proprietary information inappropriately. The confidentiality agreement also includes the following invention assignment provision, whereby the employee agrees to assign to Canoo all inventions created and or developed by the employee while employed at Canoo. So if they work on any patentable stuff, they would have to assign and make Canoo the owner of that patent, since they are employed by Canoo to do specifically, that and come up with designs and patents for Canoo. Paragraph 48, upon departure from Canoo, Canoo requires each employee to execute an employee separation information letter. The separation agreement strictly prohibits the employee from emailing any Canoo documents or information to a personal email account, and requires the immediate deletion of any such document or emails with written confirmation to Canoo of such deletion. It requires employees to return all of Canoo equipment and documents in the possession of the departing employee, and expressly requires the employees to observe and abide by the terms of the confidentiality agreement, which includes the inventions assignment provisions. So again, we're going to assume all the accused parties here probably signed this employee separation information letter, although that is assumption. I can't comment if they did or not, but it stands to reason that they probably did if this was standard operating procedure for departing employees. All right, now we're under C. Wicker and Charbonneau joined Canoo shortly after its formation, followed by Eberts. Paragraph 49. Before joining Canoo, Wicker, Eberts, and Charbonneau worked together with Harris at Faraday in Los Angeles, where they conspired and schemed to own and control their own EV company one way or another. Paragraph 50. Canoo believes it was at Faraday where Harris, Wicker, Eberts, and Charbonneau honed their tradecraft of stealing intellectual property for personal financial gain. In lieu of starting an EV company using their own independent work, the four decided that it would be far more expeditious would be far more expeditious and inexpensive to do so by stealing privileged information and intellectual property while learning what works and what doesn't work, all at the employer's expense. Such an unfair competitive advantage would prove, and indeed did prove, attractive. Okay, then it goes into each of their duties, what they were in charge of at Canoo. And then at the end here, it alleges that neither Eberts nor Wicker nor Charbonneau intended to comply with the terms of their confidentiality agreement, but instead sought access to Canoo's trade secrets and confidential information, which Eberts, Wicker, and Charbonneau used to ultimately start and control their own competing EV company. Under Part D, Harris, Eberts, Wicker, Charbonneau conspired to form Harbinger and misappropriate Canoo's trade secrets and confidential information. Paragraph 59. When Wicker, Charbonneau, Eberts executed the confidentiality agreement and separation agreement, okay, I stand corrected, it sounds like they all did. We can confirm they all did sign the separation agreement. Back to the paragraph. They never had any intention of complying with their terms. To the contrary, they intended on using Canoo's intellectual property, business plan, and human capital to form their own competing company and attract investors by having the information ready for use. Paragraph 60. In July 2019, Eberts left Canoo. By that time, Ebert, Charbonneau, and Wicker had gained access to Canoo's trade secrets related to its skateboard technology. Canoo is informed and believes, and on that basis alleges, that when Eberts left Canoo, he took with him trade secrets and intellectual property used in and related to Canoo's skateboard technology. Paragraph 61. With Eberts gone, Wicker and Charbonneau remained at Canoo together for another 17 months to work as moles so that they could continue to obtain Canoo's going forward trade secrets and confidential information, relaying that information to Eberts and Harris as they continued to craft Harbinger's foundation. And just 1 second here. Let's see.
Your chair, Dr. Evil.
Thank you. Whoa! A boo. Thanks. Skedaddle.
Paragraph 62. The two moles embedded themselves in Canoo, taking on any task that would give them broad access to and directional control of Canoo's intellectual property portfolio in various lines of business. Under the guise of employment, Wicker and Charbonneau spent their days learning the names and jobs of key engineers, commodity purchasers, and business development professionals, as well as Canoo suppliers, vendors, investors, and partners. Paragraph 63. Wicker and Charbonneau began working on Canoo's skateboard business plan, Wicker almost exclusively, and eventually the MO program. The MO program required modifications to Canoo's existing skateboard technology, and Canoo tasked Wicker and Charbonneau with managing those modifications. As part of their work on those programs, Wicker met with investors, created slide decks, and worked with other Canoo employees. For the next 5 months, Wicker became intimately familiar with all aspects of the MO program. Wicker and Charbonneau shared this information with their co-conspirators, Harris and Eberts. And go down to footnote number 10 here. Throughout his tenure at Canoo, Wicker continuously and systematically stole Canoo's confidential information and trade secrets by forwarding emails to his personal email account, as well as copying, downloading, and or uploading Canoo's confidential documents, including portable units. Wicker then shared such information with Harbinger, Harris, and Eberts. Additionally, plaintiff is informed and believes, and on that basis alleges, that while Wicker was at Canoo, he and Charbonneau conspired to and did intentionally sabotage Canoo's relationship with MO to allow Harbinger the opportunity to form such an advantageous partnership. Paragraph 64. Ultimately, Canoo's skateboard business plan, the multi-million-dollar business plan to develop modular independent driving platforms that could be sold to OEMs for use in aftermarket delivery vehicles, cemented Harbinger's direction. In December of 2020, Wicker left Canoo, leaving Charbonneau as the lead mole and one of the primary co-conspirators, continuing to steal Canoo's confidential information and trade secrets on Harbinger's behalf. Paragraph 66. Armed with the trade secrets related to Canoo's skateboard technology and valuable skateboard business plan, Wicker, Eberts, and Harris sold the idea of a ready-made EV company to early investors, including Dusastre. Paragraph 67. The Harbinger investor defendants were well aware that Harbinger's business plan to develop modular independent driving platforms that could be sold to OEMs for use in aftermarket delivery vehicles was taken from Canoo through improper acts of corporate espionage. Footnote number 11. For example, Canoo explored a partnership and even signed a non-disclosure agreement with Kalyani Transmission Technology, an affiliate of Bharat Forge. Bharat Forge is one of Harbinger's investors who recently announced a partnership with Harbinger. Bharat Forge therefore knew, or had reason to know, that Harbinger had, at minimum, misappropriated the skateboard business plan and, in particular, Canoo's supplier lists. Back to paragraph 67. It is inconceivable that a startup company like Harbinger could independently develop such intricate technology in such a short period. Paragraph 68. The Harbinger investor defendants also knew of Harbinger's plan to poach Canoo employees like Charbonneau, Mr. F. Patel, and so many others. This made the investment even more attractive. They were able to bypass the time and substantial expense associated with the development of an EV business. Moving on to subheading E, Harbinger launches. Canoo believes that once Wicker, Charbonneau, Eberts, and Harris had stolen enough of Canoo's intellectual property to safely move forward with product development and raise capital, they registered the company as Electron Transport. In or about February of 2021, subsequently, Electron changed its name to Harbinger. According to Harbinger's website, Harbinger created a driver-focused chassis architecture designed to improve safety, driver experience, and productivity. The vehicle will feature autonomous-ready drive-by-wire steering and enhancements to vehicle ergonomics, including a best-in-class floor height below 28 inches and a novel front suspension that reduces vehicle overhang. Paragraph 72. Several of these specifications were copied from Canoo's skateboard technology. They were essential to the skateboard business plan and the MO program. And by this time, Charbonneau had spent 2 of his 3 years at Canoo as a key manager and designer of Canoo's skateboard technology. Footnote 12. Charbonneau is a lead inventor on several Canoo domestic and international patent filings. Back to the paragraph. Charbonneau had access to Canoo's design specifications, production needs, and other trade secrets and confidential information. Charbonneau's knowledge of Canoo's skateboard technology was critical to the development and launch of Canoo's skateboard business plan. Paragraph 73. Charbonneau remained as the lead mole at Canoo for more than 15 months after Wicker's departure, allowing him to further misappropriate Canoo's intellectual property for Harbinger's benefit. Charbonneau knew the importance of the skateboard business plan to Canoo's long-term success, so, on information and belief, he took action to sabotage Canoo's skateboard technology and skateboard business plan, while continuing to provide competitive intelligence to Harbinger. Paragraph 74. To copy Canoo's skateboard technology and execute the skateboard business plan stolen from Canoo, Eberts, Wickard, Charbonneau, and Harris knew that Harbinger would need talented engineers and employees deeply familiar with EV technology, and they knew exactly where to look. Using Canoo's confidential information and trade secrets related to Canoo's employees, Eberts, Wicker, Charbonneau, and Harris strategically recruited the following employees to work for Harbinger, bringing with them the vast amount of confidential information and trade secrets that they themselves stole from Canoo. Patel. During his 27 months at Canoo, Patel was the Director of Commodity Purchasing with Canoo in charge of Canoo suppliers' relationships, production needs, and purchasing information. Patel's access to Canoo's purchasing needs and supplier relationships was critical to the profitability of Canoo's skateboard business plan and integral to Harbinger's scheme. Recent evidence confirms Patel stole supplier lists from Canoo. While at Canoo, Patel was directly involved in exploring a supplier relationship with Kalyani Transmission Technology, which signed an MNDA with Canoo in July of 2020. Kalyani's presentations to Canoo outlined its product development and engineering capabilities, processes, and lead times. When Patel joined Harbinger in March of 2022 and discovered Harbinger's needed a manufacturing partner for the drivetrain in its driving platform, Patel looked to his supplier list stolen from Canoo. In September of 2022, only 5 months after Patel joined Harbinger, Harbinger announced a joint venture with Kalyani Powertrain Limited, an affiliate of Kalyani Transmission Technology. Moving on to Mr. F. Mr. F., a self-described experienced business executive and corporate attorney, served as in-house counsel for Canoo for 37 months, initially as Deputy General Counsel and subsequently as Canoo's Vice President of Corporate Legal, Securities, and Global Strategy. Over this time, he oversaw a broad spectrum of different items for Canoo. It says that he had intimate knowledge of Canoo's intellectual property portfolio, and ultimately, Canoo trusted Mr. F to provide advice and counsel free of fraud, theft, and divided loyalty. Unfortunately for Canoo, its trust in Mr. F was misplaced. Mr. F grossly abused his fiduciary position, stealing untold amounts of Canoo's intellectual property, and even misrepresenting on several occasions that he would not join a competitor. Mr. F knew, or should have known, of the devastating impacts often caused by an attorney violating his ethical and professional responsibilities, yet he intentionally cast them aside. Footnote number 14. Mr. F was also a member of Canoo's business development team, where he assisted in setting and developing plans for business and revenue growth, researching and planning new market initiatives, and meeting with business partners. In his role as both an attorney and business development manager, Mr. F had intimate knowledge related to all of Canoo's business strategies. Stephen Offutt. During his nearly 4 years at Canoo, Offutt was in charge of manufacturing, battery, powertrain, and general assembly. During this time, Offutt gained detailed knowledge of Canoo's technology, partners, and business plan, including the MO program. This included a wealth of information regarding manufacturing and assembly of skateboards, including suppliers and service providers, assembly, subassembly, timing, shipping, and logistics. He was also involved in developing and building a manufacturing facility able to build skateboards at scale for the MO program. Paragraph 75. Charbonneau, Patel, Offutt, and Mr. F decided to remain at Canoo after being recruited by Harbinger to continue stealing Canoo's trade secrets and confidential information. 76. Over the course of the next 2 years, Harbinger continued to solicit, hire, and encourage Canoo employees to misappropriate Canoo's trade secrets and confidential information, including 14 former employees who had patent applications, including unpublished applications, pending at the time of their departure from Canoo. 77. In sum, Canoo is informed and believes, and on that basis alleges, that Wicker, Charbonneau, and Eberts conspired to form Harbinger prior to departing Canoo, solicited other employees while still employed by Canoo to leave Canoo and join Harbinger, and 3. Continuously and systematically shared Canoo's trade secrets and confidential information with Harbinger, both while still employed at Canoo and upon the departure, and or 4. Incentivized other Canoo employees to proactively steal Canoo's trade secrets and confidential information. And then there's a table that they provide that shows the Canoo employees left to join Harbinger, and I'm just gonna zoom out, and you can pause if you want to review in greater detail. Now we get to some particularly juicy drama here. Smoking gun kind of seems like it under F. Harbinger utilizes Canoo's trade secrets and confidential information. Paragraph 80. Harbinger's serendipitous scheme began to unravel in March of 2022 when Canoo mistakenly received an email from one of its outside law firms that included 3 patent applications. Those patent applications listed Harris, Eberts, and Wicker as the inventors. Paragraph 81. Harbinger had engaged Canoo's own outside patent counsel for patent work. Privileged information that Mr. F, as Canoo's Deputy General Counsel, would have known. It is particularly telling that Mr. F left Canoo for Harbinger on March 11, 2022, just 6 days before the patent application were sent by mistake to Canoo. Given that the patent application drafting process is generally several months long, the process as to Harbinger's patent sent to Canoo was ongoing through at least the latter months of Mr. F's tenure at Canoo. Canoo's outside law firm and Mr. F's ethical duties and obligations to Canoo were neither disclosed, discussed, nor waived by Canoo. Paragraph 82. Mr. F, by working for Harbinger while still employed at Canoo, flagrantly disregarded his ethical duty to his then client Canoo to avoid conflicts of interest while promoting the misappropriation of his client's trade secrets by his own current and former employees. Even if Harbinger's patent applications involved EV technology not identical to Canoo's skateboard technology, or more broadly Canoo's EV technology, the underlying technology was developed by Wicker and Eberts, who were previously employed by Canoo. Thus, Harbinger's patent applications involve technology potentially derivable from Canoo's technology and possibly assignable to Canoo pursuant to the invention assignment provision in the confidentiality agreement. Mr. F, an attorney, knew that. Paragraph 83. On September 14th of 2022, an article titled, "What the Hell is Harbinger and Why Are They Showing a Boring Delivery Van at the Detroit Auto Show?" appeared online in the Autopian, a startup website self-described as car culture website run by obsessive car nerds. The article discusses an auspicious blue delivery van on a sizable plot of show floor marked Harbinger, stating, "That blue van up there looks to be an off-the-rack Grumman MT45 step van sold as a Freightliner MT45 or a Morgan Olson Route Star, or some confusing combination of those names. It's a boring, useful delivery van, and I think that's the whole point." You see, Harbinger is in the business of making electric delivery van chassis, and I think they're very smart to make them work with one of the most common van bodies available, instead of succumbing to the temptation of making something sleek and cool and new looking that will get a lot of attention, but will be expensive and effectively unavailable. Paragraph 84. As captured in the article and using Harbinger's own words, Harbinger's scalable strip chassis has been built to support all of the popular medium-duty body types available today, including commercial walk-in vans, recreational vehicles, box trucks, and others. The front overhang is reduced by Harbinger's innovative independent front suspension, and the tight integration of battery, powertrain, and frame allows a best-in-class floor height. Steer-by-wire and brake-by-wire systems offer greater flexibility for driver positioning and prepares fleets for future innovations in autonomy and advanced safety. Paragraph 85. The article concludes that this is exactly what the delivery market needs if it's going to move to electrification, something that works with equipment that's already in place, loading docks, racks, and other interior van organizing systems, has driver and operator familiarity, and so on. Paragraph 86. The information confirmed Canoo's suspicions. Harbinger had copied Canoo's skateboard business plan and its skateboard technology. Rather than assign the associated intellectual property to Canoo as required, Eberts, Wickard, and Charbonneau stole it for Harbinger's use. Paragraph 87. The article further confirms that Harbinger's entire technology and business model was stolen from Canoo's skateboard business plan involving its MO program. More egregiously, Harbinger's first partner was MO. Undoubtedly, Wicker, Charbonneau, and Mr. F used confidential information discovered through their involvement with the Canoo MO negotiations over the course of a year and a half to solidify the Harbinger MO venture. Paragraph 88. Additionally, plaintiff, that's Canoo, is informed and believes, and on that basis alleges, that while Wicker, Charbonneau, and Mr. F were at Canoo, they conspired to and intentionally sabotage Canoo's skateboard technology and its relationship with MO to allow Harbinger both the time and opportunity to form such an advantageous partnership. Paragraph 89. Indeed, Harbinger stole Canoo's valuable trade secrets, confidential information, skateboard technology, skateboard business plan, strategic partnership, investor and vendor opportunities, and employees, and leverage the same into a successful business model. Defendant's calculated and systematic misconduct, theft of trade secrets and confidential information, and acts of corporate espionage is the pillar of Harbinger's success while costing Canoo hundreds of millions of dollars. All right, here we get to the first cause of action. I'm going to be honest, all of these causes of actions they kind of repeat themselves. I'll kind of say the same thing and basically just rehash everything that we've already gone over. Simple is that Canoo's accusing them of misappropriation of trade secrets and not following up to their fiduciary duties and not assigning inventions that they should have to Canoo. It's pretty much the same thing over and over again, just different capacities, different worded. And so we're not going to go through all of them. They're pretty much the same thing. But I will scroll through and you can pause as we go if you actually do want to read through all of these. Okay, here we have the demand for relief section. This is where Canoo outlines what they're hoping to be awarded as the outcome of the lawsuit. 1 through 4 here is kind of like show me the money. They want Harbinger to cough up money, including punitive damages, which is sort of like an extra fee on top to make an example out of them as a warning to anyone else in the future thinking of doing the same things. Number 5 is for patents and inventions that are under Harbinger but based upon or directly using Canoo's IP that Canoo wants that transferred and assigned to Canoo. 6 through 9 is asking for relief orders, basically telling Harbinger to stop using Canoo's trade secrets. 10 and 11 are asking for any documents or files, anything related to their trade secrets be returned to Canoo. Number 12 is asking for attorney's fees and costs. Number 13 is asking for prejudgment and post-judgment interest, which is basically an interest rate applied to any monies Harbinger made that are considered ill-gotten while using Canoo's trade secrets. And 14 is again asking for the return of Canoo's trade secrets and confidential information still in the possession of individual ex-employees. And then 15 here is basically any freebies the court might decide is owed to Canoo. So, I mean, that's it. That's all she wrote.